had a layoff maybe 6 months before. They had a layoff. And now they brought in, not only that, you have Disney scenario. Disney had a big case. Because of Disney, Senator Grassley wrote a letter to the DOL, finding out what the hell you guys are doing, you see. So Disney laid off the multiple employees, right? And then hired worker from Tata, H-1B worker. So that scenario became a layoff. The Tata's defense was, within the spectrum of the current immigration and the labor regulations, you do not have to worry about this displacement rule if you have an exempt LCA. If you're paying more than $60,000, or the guy holds a master's degree in a relevant field being South. So they used that logic. They said, this non-displacement rule really doesn't apply to us. The government they did not want to let them go. They will find other tricks to put a hat on him. So they just continued the investigation. But this is how the layoff takes place. Because if there is a placement of the H-1B worker, and a few months before there was a displacement of a layoff of the US worker. But the law is very complicated and complex. But it says the job duties must be 100% similar. If the computer programmer analyst was laid off, or you sent the guy on H-1B as a software engineer, so there is no conflict with the layoff. It's a different job, you see? So the layoff rule, they use in between in a massive layoff situation. But as a dependent employer, you have to pay attention to those details.